Since the time of the first Norman king William the Conqueror, the United Kingdom has implemented a common law system. The courts have always played an active role in the running of the state through various categories of the law.
Administrative law is the law concerned with the administrative activities of a government. The role and purpose of administrative law varies depending on the theory that we conform to. There are various theories of administrative law such as the red light, green light, amber light, and rights-based theory.
In light of the question today, we'll be determining the most relevant theory based on how the UK courts have responded to the various regulations imposed by the UK government to combat this pandemic.
This will be done by analysing the stance of the courts in regard to the various cases that have been brought up pertaining to the new legislation imposed for the COVID-19 pandemic.
It is likely that the courts have since adopted the green light theory of administrative law, whereby the courts are taking a step back and handing the reins over to the executive body, prioritizing national interests over individual autonomy in order to effectively combat this health crisis.
Red light theorists believe that the core purpose of administrative law is to ensure that the power exercised by the executive body remains within the constraints of the power that has been granted to them by the legislative body. In the famous words of Professor Wade, that the powerful engines of authority must be prevented from running amok. The primary objective encapsulated within red light theory is the protection of an individual's rights and autonomy. Hence, in order to achieve this administrative justice, executive accountability and good administration are vital. The executive body is typically subject to two types of control: political control from Parliament as well as legal control from the courts. The main difference between red light and green light theories is whether or not the powers of the executive are subject to judicial control, which typically takes the form of judicial review. The doctrine of judicial review upholds the interpretation of the concept of the rule of law, ensuring that the powers exercised by the executive body are not ultra vires. A relevant question in regards to the red light theory and the rule of law is whether or not the government should be able to exempt certain activities from judicial review through ouster clauses. Lord Denning believes that individuals should always be able to challenge the decisions of governmental bodies in courts. In the Ennis Minute case, Lord Denning also suggests that Parliament may be able to avoid this principle, but only through absolutely unambiguous statutory formula. From this, we can derive the importance of upholding the rule of law in regards to protection of citizens' rights. In simple words, red light theorists view administrative law as a tool through which the protection of citizens is guaranteed by upholding the principles of the rule of law.
The green light theory of administrative law prefers the idea of control and accountability through democratic political processes, focusing on creating a government with good administration and its own efficient democratic processes and internal controls. Green light theories do not deny the importance of an individual's rights and autonomy. They merely prefer the aforementioned method of doing so. Although the result may sometimes compromise an individual's rights, this is defended on the basis that wider powers of the executive assist the functioning of the state, which has a wider commitment to national interests. Green light theories want to encourage efficiency in the governing process, as opposed to intervention by the courts, providing political accountabilities as opposed to legal accountability. They encourage looser legal constraints on government discretion, enabling the government to curb individual autonomy in order to promote society's collective well-being. They see the role of law as being primarily to enable the government to achieve important public goals effectively, such as education, health, and social welfare. A common metaphor used by Griffith and Street regarding control: a driver controls a car. However, a policeman may stop the driver for speeding. This is an example of an external controls that aren't judicial. These are checks and balances that exist regardless of interference from the judiciary. Through ministerial responsibility and the supervisory hierarchical structure within government bodies. The Parliamentary Ombudsman was introduced for the purpose of investigating complaints made about governmental departments and public bodies.
Essentially, the rights-based approach is about human rights. What are human rights? Human rights are the basic rights and freedoms that you are entitled to. To advocates of the rights-based approach, human rights are of utmost importance. They have a higher status and have a position above ordinary law. Also, human rights are capable of curbing the decisions of the executive, notwithstanding the fact that it may be in public interest, a metaphorical trump card as Ronald Dawkins called it. Courts have a duty to uphold human rights, to ensure that the decision of the executive does not negatively affect human rights. This is through the process of judicial review, and judges following the rights-based approach are more likely to focus on human rights that have been infringed in addition to the procedure in which the decision was made. Since the integration of the Human Rights Act 1998 in domestic law in the United Kingdom, courts place certain human rights on a higher pedestal, employing a more rights-based approach.
Amber-like theory is the middle ground of the administrative law theories. Although it strongly resembles the right-based approach, it expands beyond just protection of an individual's constitutional rights. It is in between the two extremes of the green light and red light theory. It takes the view that application of administrative law will be determined on a case-to-case basis. This suggests that control mechanisms should be found both internally and externally, hence allowing a more flexible approach. According to Lisa Webby, the law should intervene when executive discretion has an impact on individuals' constitutional rights. The interference that comes along with the red light theory adversely affects state activities, hindering them where the judiciary intervenes with the affairs of the executive. However, the freedom and non-interventionist approach of the green light theory can lead to the abuse of power and the breach of individuals' rights. Hence, a hybrid approach combining both theories might result in the best outcome. According to Adam Tompkins, there are four main principles that amber light theorists abide by. The first is that governmental powers, which are above politics. Next, the executive is subject to legal control, albeit said control should be relaxed to allow the executive to enjoy some discretionary power. Thirdly, the best way of controlling the state is through judicial articulation and enforcement of broad principles of legality. Lastly, the core purpose behind this theory is the protection of a certain degree of human rights. An example of this can be when the parliament confers a broad discretionary power on a decision maker and they exercise their discretion that touches on what judges hold as a fundamental right. Having analysed the administrative theories, what approaches have the UK courts taken in regards to administrative issues? The application of the red light theory in the UK has been popular, with courts taking active roles in regulating the execution of governmental powers. However, due to constitutional principles adopted in the UK, such as parliamentary sovereignty, the courts have also acted cautiously, reviewing cases but ultimately employing a more green light approach in the decision. The courts are sometimes unwilling to interfere, where the actions of executive bodies are still legal but still infringe upon people's rights. This is because it is up to Parliament to decide the limits on powers delegated to certain authorities, being the democratically elected supreme law of the land. It is important to note that in practice, courts recognize the distinction between the legality of a decision and the morality of a decision. The following cases illustrate how courts have taken different approaches to dealing with cases regarding administrative law.
Important case in regards to administrative law in UK is the Ennis-Minnick case regarding the deployment of ouster clauses. Parliament's increasing predisposition to deploy ouster clauses was seen to completely negate the court's powers of judicial review, where legislation contained ouster clauses. However, it was held in Ennis-Minnick that the provision of ouster clauses was not enough to oust judicial review for an error of law. In Wade's view, the very existence of such legislation showed an unhealthy disrespect for orthodox principles of the rule of law. Professor John Griffith, however, approved because he felt that the courts were intruding unconstitutionally on the sovereignty of Parliament. Hence, it is clear that while the red light approach can sometimes be difficult to implement in reality, due to the doctrine of parliamentary sovereignty, courts will uphold the doctrine of rule of law as far as possible when implementing the red light theory.
The Wednesbury Corporation case demonstrates a more green light approach that courts have chosen to take when it comes to upholding the supremacy of Parliament. In this case, the courts held that the standard for proving unreasonableness was a high one, where the authority must have acted in a manner that was so unreasonable that no reasonable authority could have ever come to it. Otherwise, the courts would prefer not to interfere with the decisions made by executive bodies and will merely enforce the will of Parliament. Gans, a prominent administrative law writer, agrees with this approach, stating that judges should never interfere with the allocation of functions as established by statutes, as by doing so, they are substituting the courts for the rightful decision maker as chosen by Parliament.
The application of the green light theory is not foolproof. Issues of ministerial responsibility have also arisen. For example, in the case of R. Abbasi as Secretary of State for Foreign and Commonwealth Affairs. In this case, the Secretary of State, who is the Cabinet Minister in charge of the government department, should have a wide discretion to exercise its prerogative power, and the court, who is the judiciary, should not encroach the forbidden area like foreign policy. However, it was held that it is possible for the court to review the decision by the Secretary of State if there is an element of irrational and illegitimate expectation.
It can be observed that the tests used by courts in pre-Human Rights Act and post-Human Rights Act cases were different and produced different outcomes. I'll be using the cases of R in Ministry of Defence ex parte Smith and Smith and Grady and United Kingdom to illustrate this observation. R in Ministry of Defence ex parte Smith is a pre-Human Rights Act case, and it involved a policy which forbid persons with same-sex sexual orientation to serve in the armed forces. The court acknowledged the infringement of human rights but did not interfere because such policy was not unreasonable. Here, the court used the Wednesbury unreasonableness test, which promoted the doctrine of judicial deference, whereby courts will not interfere with the actions or decisions of the executive unless they are unreasonable. Smith and Grady and United Kingdom, on the other hand, is a post-Human Rights Act case, and it involved the applicants in the aforementioned case. Here, the European Court of Human Rights used the proportionality test and decided that the infringement of human rights was disproportionate and unjustifiable, and that any person, regardless of their sexual orientation, was allowed to serve in the armed forces. The application of different tests resulted in different outcomes, one favorable and the other unfavorable. This possibly illustrated the positive influence of the Human Rights Act 1998 on judicial review, specifically how the proportionality test achieves the objectives of the rights-based approach by providing a greater protection of human rights in comparison to the Wednesbury test alone.
In the UK, Several statutes were passed to control the spread of the virus. This includes the Coronavirus Act 2020 and the Health Protection Coronavirus Restrictions Regulation 2020 in England, Wales, Scotland and Northern Ireland. Effectively, the executive government is equipped with discretionary power. The regulations, though not entirely the same amongst the devolved nations, grant the government power to restrict movement, gatherings, and fine and arrest those who violate the lockdown. The Coronavirus Act also allows the government to detain those who are suspected to be infected by the virus and intervene in regulations across a wide range of sectors. However, it is important to note that the obligation under the European Convention of Human Rights has not been suspended following the passing of the Act. During the Lord's debate on the bill, Lord Bethel declared for the government that every exercise of power by a public authority under this bill is already required to be compliant with the Human Rights Act 1998. I further reassure the House that at all times this government will act with proportionality. To curb the spread of the virus, a nationwide lockdown was announced 23rd March 2020, and the powers discussed above were given to police authorities to help facilitate the lockdown. Businesses were shut down, and only essential workers are allowed to work. However, when laws are enacted under pressing and rushed circumstances, executive bodies going beyond delegated powers under the Acts, whether intentionally or otherwise, can easily happen. The impact of these regulations are significant as it deprives fundamental rights under the ECHR, such as the right to liberty, Article 5, freedom of religious practice, Article 9, and the right to assembly, Article 11. However, as said in the case of Soaring against UK, these measures need to be necessary, balanced, and for the general interest of the community. A number of other responsive measures in Britain were tried and were found insufficient. Social distancing advice was effectively ignored. The idea that the measure must be the last resort was the most decisive criterion in Ejin against Sweden, a European Court of Human Rights case which analyzed deprivations of liberty to deal with infectious diseases. Currently, courts in the UK seem to be acknowledging that a temporary curtailment of individual rights and liberties can be justified given the dire circumstances of COVID-19. This was demonstrated in the case of BP against Surrey County Council, where a care home had exercised its discretion in banning visitors, per government guidance at that time. The claimant is deaf and was diagnosed with Alzheimer's disease. His daughter, on the behalf of the claimant, contended that the ban on visitors is a violation of Article 5 and 8 of the Convention. While the court recognized that it is the state's obligation to ensure that people with disabilities are treated equally in the face of the pandemic, it did not expressly provide that the visitor ban was disproportionate to controlling the virus. Instead, it gave a judicial approval to the plan drawn up to maintain as much virtual contact with his family. Therefore, in uncertain times like this, courts would generally prioritize public health interests over other individual liberties. That being said, courts would also adopt creative solutions to ensure that the impact of depriving other individual liberties is not too significant. Furthermore, the case of Verde against the governor of HMP Wandsworth involved a habeas corpus application where the applicant was awaiting extradition which had been delayed due to the pandemic. The applicant contended that the continued detention was unlawful, but his application was dismissed. Contrastingly, the case of R on application of Jallo against Secretary of State for the Home Department showed that the courts were more willing to intervene pre-crisis. Here, the Supreme Court unanimously held that subjecting a claimant to a curfew restriction amounted to a tort of false imprisonment. Hence, looking at the current situation, it's clear that the United Kingdom courts have taken a step back in order to allow the government to take the measures needed in order to effectively combat this health pandemic. However, it is clear that the courts are not completely washing their hands of the situation, they are merely facilitating the government. The Administrative Court Office has prioritized urgent applications for judicial review, which are ones where it is argued that irreversible action will take place if the courts do not act and where expedited judicial review is needed. So yes, legal control has been relaxed, but it still remains alongside strong political control. While Parliament has granted wide discretionary powers to public authorities, the power of the people through political sovereignty still remains, and this is seen through various activist groups that have been active during this pandemic, such as the Detention Action Group, fighting for the rights of immigrants during the pandemic, as well as the British Institute of Human Rights, fighting against discrimination of the elderly during the COVID-19 pandemic. Having analysed the way the United Kingdom courts have responded to this pandemic, let's take a look around the world to view how the court systems in other countries have responded to this pandemic. In Germany, an amber light approach has been implemented. In USA, a green light approach similar to the United Kingdom has been implemented, while in Jakarta, a red light approach has been implemented. Let's take a look.
In Germany, the Constitutional Court partially upheld a group's bid to demonstrate in public against the coronavirus restrictions in the small town of Gießen near Frankfurt. The Constitutional Court did not demand that the previously banned protests, which had taken the motto of strengthen health, do not weaken rights, protect against the virus, not people, must go ahead. Instead, it ruled that the existing court bans were not acceptable and called on local authorities to reconsider the case themselves. Very soon after the ruling, the mayor announced that the protests would be permitted without further court attention. There were some caveats, though, such as limit on the number of participants and duration of the event. Participants will also be required to wear face masks and keep at least 1.5 meters away from each other.
To examine the situation in the United States, we can perhaps look at some cases. In Lighthouse Fellowship against Northam and Gish against Newsom, the plaintiffs wanted to have religious gatherings, and they believed that they had the freedom to exercise their religion and speech as per the Constitution. However, religious gatherings are not allowed under stay-at-home orders. In Lighthouse Fellowship, the court held that the Constitution does not impart an absolute right to a person and that there are restrictions for the common good. In Gish, the court also held that the defendant has a right to protect Californians from the disease even if it temporarily burdens constitutional rights. In both these cases, we can see that the court reaffirms governmental decisions despite those decisions being questionable as per the Constitution, as they place a higher importance on public health rather than constitutional rights.
In Jakarta, the government has asked the Constitutional Court to reject a petition for judicial review. A regulation in lieu of law, Perpu, regarding the extension of budget deficits during the COVID-19 period was passed, giving rise to Article 27, which protects government officials of legal charges for their fiscal and monetary decisions, as long as they act in good faith and according to the law. The plaintiffs, a group of anti-corruption activists, argued that this article might be in breach of other state laws. They also argued that the passing was too quick, as constitutionally, a Perpu must obtain the House approval in the next sitting period. Since this Perpu was approved or issued by the President during the House third sitting period, it means that the approval should be in the fourth sitting period. The government argued that the petition should be rejected as the Perpu was already passed as a law.
We have analyzed the spectrum of administrative theories and various cases that have been brought up pertaining to the new legislation imposed for the COVID-19 pandemic.
We can henceforth concretely conclude that the most relevant theory that courts have since adopted, based on the recent worldwide events, is the green light theory of administrative law.
The courts have taken a step back and handed the reins over to the executive body, prioritizing national interests over individual autonomy in order to effectively combat this health crisis. These cases clearly demonstrate a shift in the court's approach, trading off individual rights for social benefits with certain limits to ensure some level of accountability for the government.
Our rights are still in our hand, despite the measures implemented by the respective governments. Hence, it is imperative that access to some checks and balances remain available to the citizens.
Quoting the World Health Organization in 2008 regarding the influenza pandemic, countries should have procedural mechanisms in place for groups to challenge the unjustified use of quarantine or isolation power. This is especially important, quoting Sir John Laws, that a democratic constitution is, at the end of the day, undemocratic if it gives all its power to the elected government.